My name's David Levin, and I'd first like to correct some misleading and deceptive material which has been presented to you. I'm not currently the chair of the Victorian Bar Dispute Resolution Committee, I'm afraid. I was about 4 years ago. So that's long past, I'm afraid. And I also didn't sign the bar roll in 1997, but actually 1977. Of course, my youthful good looks belie that, but anyway. We are here in interesting times for arbitration. We've got a relatively new Act. Certainly in Victoria it's pretty new for practitioners. We've got a judge in charge of the arbitration list, the Honourable Clyde Croft, who is enthusiastic when it comes to arbitrations, and perhaps more important, extremely knowledgeable, and has had a background in practice in arbitration as a practitioner for parties and for an extended period as an international arbitrator himself. So that, and he's established a working system in the Supreme Court which allows one to get a hearing on a procedural aspect of an arbitration which is going down the wrong path very quickly. And that's extremely important to allow people to have confidence that if they embark on the arbitration path, they're going to be able to get through it without lengthy delays if there are any problems. And generally in the court, there is of course enthusiasm, and there has been for the past 10 years or so, for alternative dispute resolution. So arbitration is a limb of that. If you can resolve your dispute outside the court, generally speaking, you ought to be able to get it resolved more quickly. There's been a long time criticism of, say, the past 25 years of arbitrations in Victoria as being more and more judicial. You know, more discovery, more of the court processes being adopted and assimilated into the arbitration process. Perhaps there's a push back against that now because the courts themselves are pushing back. You know, we've got the Civil Procedure Act. General discovery is now not acceptable in the commercial lists, and so arbitrators, I hope, are going to feel more confident in knocking back those sort of applications for wide and expensive discovery and limiting matters. So today we have two very experienced practitioners. We've got Michael Roberts, who from his CV, I won't go into it because it's there for you to read, has been involved in many arbitration matters and matters arising from arbitral proceedings which had the misfortune to proceed into the court system, and he will be able to provide a great deal of information and knowledge to us today. And David Bailey, David, who was a member of the working group of the Commonwealth AG on commercial arbitration and the new model law legislation, so that he is a person who's had a real insight into how the new legislation was drafted and why, and what it's intended to achieve. So without any more ado, we're going to have time for questions because we've started promptly. I think it's probably better to hear both papers and deal with questions at the end, but if you've got any particular questions after one of the addresses, then do indicate. Okay. Thank you very much. David.
I always seem to be at sessions where there are more than one David, which is very handy. Well, good morning everybody, and thanks for coming in so early. My focus might be thought to be a little bit trite in some ways, particularly with such, looking around the room, people who've got as much experience as I have, I suspect. But because of the new regime under the Commercial Arbitration Act of 2011 in Victoria, which is based on the model law, some of the things we've been taken for granted over the years in terms of what an arbitration agreement is, have been slightly altered, and I think it's worth just refreshing our approach to those matters. Thought I'd start off by just saying, by way of overview, the importance of the agreement to arbitrate has at least 4 consequences. The first one, which is fundamental, and that is that it's the source of the jurisdiction. I think the word jurisdiction might be a bit questionable in some quarters, but jurisdiction, power or authority of the arbitrator or the tribunal to conduct the arbitration. So without that, the arbitrator is not clothed with any authority at all. And secondly, which is a corollary of that, and that is just what range of disputes does the arbitrator have. The agreement will direct the scope of the dispute, and one hopes that it's wide enough to embrace the dispute which has arisen, and that's often a focal point for litigation. The third matter is the primacy of the agreement. That is that what comes out of the model law and the earlier New York Convention is that the arbitration agreement is enforced by the courts such that if one party issues a proceeding in court, the other party who would prefer to arbitrate may apply to court to stay the proceeding. Well, that principle is carried forward into the Commercial Arbitration Act, and it supports the arbitration agreement. And finally, and this is another area which is currently under some disputation, what is the enforceability of the outcome of the arbitration? That again goes right back to the agreement to arbitrate, because one basis for setting aside an award is that the agreement had some invalidity. So just turning to those matters, I won't deal with them all in great depth, but the first theme I address is the agreement itself, and I pick up the definitions in Section 7 of the Victorian Act. One sees there that it's an agreement in writing, and one of the in writing, of course, has been expanded a bit by what the model law origins, so what it says there is quite helpful, so that you may have an agreement that simply follows from some correspondence, confirmation by email, something of that nature. The other aspect I think that's important is this. Let's suppose that you've got an argument about whether the agreement to arbitrate is sufficiently clear as to some matter. What happens if you issue a notice of dispute and the dispute gets underway? Well, the Act addresses that by saying in subsection 7, an arbitration agreement is in writing if it is contained in an exchange of statements of claim and defence in which the existence of an agreement is alleged by one party and not denied by the other. That's a very important provision because if, as I say, the arbitration gets underway, then, and there's no disputes raised about the content of the agreement, it may become too late to argue later on that the dispute in question was outside the scope of the arbitration agreement. That's a very useful provision, and I've had to consider it recently in relation to a matter where the parties have been in disputation about the scope of the agreement, and the arbitration was constituted and duly held. Now, perhaps turning to the jurisdiction of the arbitrator, as I've said, this rests entirely on the private agreement of the parties, and an important corollary of that is that the jurisdiction is only enlivened in relation to the parties to the agreement, not in respect of third parties. I think a rather striking illustration of the effect of that proposition is the recent Court of Appeal case here in IMC Aviation Solutions and Altain Kuda. You remembered that that was an arbitration conducted in Mongolia about a mining dispute. There were basically two parties, a Mongolian company and a company which, although it was operating out of Australia, I think was incorporated in another place. The arbitration was held for a Mongolian arbitrator and an award was delivered, and in the award another party, IMC Aviation Solutions, was found itself mentioned in the award as a co-award debtor, I suppose, put it. In any event, the award was sought to be enforced in Victoria, and at first instance on a summary application, basically the way these things happen under the International Act, the award was given effect. Now, there was an appeal to the Court of Appeal, and IMC Aviation Solutions was successful in taking the point that not only was it not a party to the agreement to arbitrate, but it did not participate in the arbitration, and thus it was not appropriate that the award be recognised or enforced against it. So unless you're a party to the agreement, then the arbitrator can do nothing. Now, in relation to a third party, just one caveat, I suppose, is that that doesn't entirely remove from the range of remedies in an arbitration the ability to go to a court to get some sort of relief against a third party by way of injunction. But that, of course, is only incidental to, say, preservation of assets or something of that nature, and it doesn't really bear on the award which is given between the parties. Perhaps I might just say something about the way the award works. There's an issue as to why an arbitration is not contrary to public policy as ousting the jurisdiction of the courts. Well, the solution to that is that what happens when you agree to arbitrate is that you designate a third party, the arbitrator, to resolve a matter between the parties in much the same way as you would mediate and settle a dispute. The effect of the award is rather like an accord and satisfaction. It replaces the original cause of action for breach of an agreement, for argument's sake, with a new cause of action, which is the right to sue on the award. And so all the arbitrator is doing is effectively helping the parties resolve their dispute by making a binding determination which replaces the original cause of action. That was held in a High Court decision some years ago in Dobbs and National Bank of Australasia. In passing, it wasn't a direct issue in the case, but the court made it quite clear that an arbitration was not contrary to public policy as ousting the jurisdiction of the court. So that's a little about the structure of the arbitration agreement and how it operates. It doesn't have to be a specific standalone agreement. It's quite clear from what is now in the Commercial Arbitration Act that an arbitration agreement can be either an agreement to arbitrate made between the parties when a dispute arises, or it may be, and is probably most common, a clause in an agreement, a dispute resolution clause that provides for arbitration. It may be part of a staged process involving mediation and negotiation first, followed by arbitration if the previous process doesn't work. But whatever it is, whether it's in the main agreement or a separate agreement, the agreement is given primacy by a doctrine which is that the arbitration agreement stands separate from the main agreement. It has a life of its own, in effect. And the reason for that is that it enables the tribunal vested with the conduct of the arbitration to determine matters such as whether the main contract has some vitiating problem, such as misleading and deceptive conduct, or in one case, the United Kingdom, fraud or bribery, without affecting the jurisdiction of the arbitrator to determine that dispute. That's come to be known as the concept of separability, and if you go to the model law and the Victorian Act, you'll find it enshrined in the legislation itself in section 16, where it provides that the tribunal can rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. So that's an important provision supporting not just the agreement but also the whole process. Now, I'll turn to perhaps the main theme, one of the main themes of today's talk, and that is the arbitration agreement as to scope. Now, this is becoming a bit of a battle. I suppose it's been a battleground for years, but it seems not to have gone away, and I think it just behoves us to perhaps have a bit of a refresher on how we got to where we are. Now, what I'm saying, as we all know, there are two different regimes for arbitration. There's a domestic regime for domestic arbitrations under the Commercial Arbitration Act of Victoria, and there's an international regime under the International Arbitration Act of the Commonwealth. Most of the decisions you find are dealing with international arbitrations, but much of what has been said recently, I think, applies to both the interpretation of arbitration clauses or agreements in international and in domestic arbitrations. But where there's a difference, we can perhaps have a discussion about that later. The question of scope was recently given a fairly broad compass by a House of Lords decision. Premium NAFTA Products and Philly Shipping Company, which is a series of shipping disputes where it was alleged that the agreements had been obtained by bribery in the shipping industry in, I think it was out of Russia. Now, the House of Lords had to consider whether the arbitration clause was wide enough to deal with the disputes as to the entry into of the agreement. And the wording in the shipping charters referred to any dispute arising under this charter. Of course, the argument against the jurisdiction was, well, you couldn't have a charter if you had bribery which led to the entry into of the charter, therefore it didn't arise under the charter. It arose before the charter, or it meant the charter could never have effect. Lord Hoffman wrote the leading judgment of the House, and he made a number of important points about construction of the clause. He says that, of course, that the scope of an arbitration clause is essentially one of construction, but adding to that, he said this: businessmen in particular are assumed to have entered into agreements to achieve some rational commercial purpose, and an understanding of this purpose will influence the way in which one interprets their language. So he's putting a bit of flavour there into why you would have an arbitration clause in the first place. And he went on to say, if an arbitration clause was included in the parties' contract, you had to inquire into the purpose for the clause. In his opinion, by including such a clause, the parties expressed the desire for the referred disputes to be dealt with by arbitration on the grounds of matters such as neutrality, expertise and privacy. They want a quick and efficient adjudication. Perhaps you ought to underline those words in light of recent experience. If the purpose of the clause is accepted on such basis, then Lord Hoffman went on to say these words: its construction must be influenced by whether the parties as rational businessmen were likely to have intended that only some of the questions arising out of their relationship were to be submitted to arbitrators and others were to be decided by the national courts. If there's no rational basis upon which businessmen would be likely to wish to have questions of validity or enforceability of the contract decided by one tribunal and questions about its performance decided by another one would need to find very clear language before deciding they must have had such an intention. Now, one can't argue with the sense of that. Why would you want to have disputes in two different tribunals or two different jurisdictions? The trouble is, how do you get there? Now, he also looked to the intent of the English Arbitration Act in supporting separability, which we just looked at a moment ago. But the key thing I think he comes to when he turns to construction is this. Paragraph 33, I've set it out. He says, in my opinion, the construction of an arbitration clause should start from the assumption that the parties as rational businessmen are likely to have intended any dispute arising out of the relationship into which they've entered or purported to enter to be decided by the same tribunal. Now, that's, I think, the big jump in his reasoning, which has led to a few issues as to just how we should approach interpreting arbitration clauses. So I've posed the question, will that approach be followed in Australia? Now, I think some of us thought that that might be the case. However, I think it's necessary to sort of just go through in a couple of steps what has happened. Going back to 1998, there was another shipping case, but it was an Australian case to do with shipping of wheat. And what had happened was there'd been negotiations about whether or not the holds of the ship were free of the disease, and the charter was entered into, and of course it turned out that the holds weren't clear of the disease, and there was a case to sort out who was liable. Now, the dispute revolved around pre-contractual conduct. There was a misleading and deceptive conduct claim under the old Section 52 under the Trade Practices Act, combined with claims under the contract itself. And the federal court had to consider whether the wording "any dispute arising from this charter" picked up the arbitration of the pre-contractual issue of misleading and deceptive conduct. And the court took the view that no, you couldn't, even though those words are fairly wide, they didn't comprehend claims under the Trade Practices Act that might arise out of pre-contractual conduct. And that was regarded, I think, at the time as being a bit out of step with an earlier decision, Francis Marketing Travel and Virgin Atlantic Airways. However, it was a very carefully reasoned decision, and we considered that, well, that was the way it was going. Now, going forward a bit to 2006, the full federal court had the decision in Commandante Marine Corp and Pan Australia Shipping, and the leading judgment in that case is of Justice Alsop, now President Alsop. He wrote what I think is one of the leading expositions of international arbitration in Australia. It's a wonderful decision in that it covers a whole range of aspects, but turning to construction of the arbitration clause, he had to look at just where we were, having regard to international practice and what had transpired elsewhere, including the House of, that's after the House of Lords. Sorry, let me make sure I got my chronology right. No, the House of Lords was 2007, I think, so he's a bit before. But in any event, Justice Alsop had to again consider the words arising out of. He noted the trend of authorities was towards a liberal approach to interpretation of such clauses, underpinned by the sensible presumption the parties didn't intend the inconvenience of having their disputes dealt with in two different places. However, I think it's fair to say he was not prepared to go so far as to say there was some presumption you started off with, but you had to adopt a liberal construction. So I don't think from that he's going as far as the House of Lords. However, he was not prepared to be as confining as the earlier federal court decision in Highfert and Kukian Traders, the one about the shipping of wheat. He considered that the words arising out of could cover wider disputes than the previous decision. Now, so we get to a point where we're looking at a more generous view of interpretation of the scope of arbitration clauses. Then come two recent decisions which I don't think they make a trend backwards, but they do make us look to the question of construction more carefully. And I think they teach us not to interpret on the basis of any particular presumption or assumption. The first of those was a case of Justice Hargraves in TCL Air Conditioner and Castell Electronics. Now, I speak from the background of having been involved in that case, so there's some things I probably can't say, but I've set out there for you the clause. Justice Hargraves was at pains to point out that this was an agreement that had not been drafted, or didn't appear to have been drafted by lawyers. It was an agreement drafted between two sets of Chinese parties, some based in China and some based in Australia, and it wasn't a particularly elegant agreement. And the dispute arose as to what disputes could be dealt with under the agreement. It was a distribution agreement, appointing one party to have an exclusive distributorship for Australia. And pursuant to that agreement, the parties had entered into a course of dealings whereby products were imported from China, obviously under the authority of the agreement, but under separate orders, and which led to separate sales. Now the question was, were all those disputes swept up under the auspices of this clause? And the arbitral tribunal had taken a very large view of the interpretation and said they could, but Justice Hargrave took a, I won't say took a microscope at the clause, but he took the view that of the words, if you look at the clause there at paragraph 51 of my paper, in case there is any breach of the provisions under this agreement by either party, they were the words. And he says at paragraph 53 of my paper, the scope of a referral for arbitration depends on the proper construction of the relevant arbitration clause. Accordingly, the role of the court in ascertaining the scope involves giving meaning to the words chosen by the parties. In that task, where the words of the clause are sufficiently elastic and general, or capable of broad and flexible meaning, they should be given a liberal construction. The justification for this is the presumption that commercial parties are unlikely to intend the inconvenience of having possible disputes from their transaction being heard in two places. And he also makes the comment, a liberal approach is justified where the parties are operating in the international market and come from different countries. So that's fine so far, and all those conditions, of course, was to some extent satisfied in terms of the parties being from different countries, and there might have been a presumption that they wanted their disputes to be all held in the one place. But His Honour was not prepared to go so far as what had happened in the House of Lords decision, and he went out of his way to say this: in my opinion, the statements by Alsop and Austin J that there's no legal presumption at work are correct and have not been altered by anything said by Alsop J and Commendato or by Lord Hoffman in Premium NAFTA. So Justice Hargraves is saying, look, there is a limit to how far you can go with presumptions or implications or large interpretations. And so by going to the words under this agreement, he said this didn't entitle the arbitrators to interpret the clause as operating as if it was some umbrella to draw in the disputes under the collateral sales agreements. Now, so that, I think, is obviously a correct decision, and I think it just sounds a bit of a word of warning in terms of where we got to with the House of Lords. Now, more recently, in the litigation between Gina Reinhardt and three of her children, a case came before the New South Wales Court of Appeal. What had happened there was that there had been an earlier family dispute about the family trust, and that had been resolved by the entry into of a deed, and then further disputes, as we know, had broken out between the children and their mother, and the question was whether those disputes ought all be confined to an arbitration hearing to be held confidentially. So this is an example of how things can blow up and not be confidential. The question was similar wording to what Justice Hargraves looked at. In the Reinhardt case, the words used were under this deed. Now, what's interesting is how Chief Justice Bathurst looked at it, and he went out of his way to distance the court from the English decision. In paragraph 121 of his judgment, he said, "Not appropriate for this court to adopt what Lord Hoffman described in Fiona Corporation as a fresh start and construe clauses irrespective of the language in accordance with the presumption the parties are likely to have intended any dispute arising out of the relationship into which they've entered to be decided by the same tribunal, unless the language makes it clear certain questions were intended to be excluded. The approach suggested by Lord Hoffman is contrary, in my opinion, to the approach laid down by the High Court as to the construction of commercial contracts." And he went on to say the expression under this deed has consistently been given a narrower construction than phrases such as arising out of. The other members of the court, Justice of Appeal McColl, Justice of Appeal Young, delivered short concurring judgments expressly adopting the same interpretation approach. So I think we reach a situation where if we're instructed to assist in drafting an arbitration agreement, to be very careful as to the definition of what disputes or the description of what disputes are to be covered. If they're to be fairly specific, then the language must be used accordingly. On the other hand, if all sorts of disputes are to be included, including pre-contractual disputes or umbrella type disputes under other dealings of the parties which arise out of the contract in some way or have some connection with it, then you need a much broader assembly of words. And one needs to be, as I say, take a step back and be very careful, taking into account those recent decisions I referred to. I also make the point, I think, that one needs not just to look at the clause itself, but the overall agreement to see that it sits in the right setting. So there's nothing in the main agreement which might confuse the meaning of the arbitration clause. The other aspect, the other side of the coin in relation to the agreement is that, and as most of us in our practices have the situation where the client comes in and a dispute has arisen, and you're called on to draft a notice of dispute, or perhaps a statement of claim if you're looking at a dispute that might be arguably outside the dispute resolution clause. Well, then you need again to look very carefully at the dispute resolution clause, and if you come to the view that the dispute falls outside the scope of the clause, then you need to adopt a bit of a strategy. Do you approach the other side to see if they're prepared to include it? That's probably maybe a bit naive. Do you simply draft a notice of dispute on a wide basis and hope that the other side will not demur from that? How do you go about it? Well, I think these are matters of obviously practice and degree. There's a lot of sense, I think, in trying to persuade the other side, if the clause is very tight, to include all disputes to avoid the problem of going to two different places to resolve two different sets of disputes. But be it as it may, I think you just need to address that question in a way which protects your client's interest and also doesn't waste a lot of money in disputation as to, how wide the clause is. I see I'm getting a wind-up. There's one last topic, I think, which is associated with the scope, and that's the question of arbitrability, which is a very curious concept. It has its life it comes originally out of the New York Convention, and it's in the model law, and it comes down to this. The wording, I think, which is used in those places is whether the dispute is one that's capable of being determined in an arbitration. Now, that initially I think was regarded as being confining, and the point came up again in the Reinhardt case as to whether disputes under a trust might be dealt with by an arbitrator. Chief Justice Bathurst engaged in a very lengthy review of arbitrability, came to the view that there was no difficulty so long as you didn't oust from the court's ultimate questions that under statute the court must decide. And he also noted a recent decision of Justice Hammerslag in the New South Wales Supreme Court in a case called Larkton and Lloyd Energy Systems, where there was a dispute about a patent, and it was to do with royalties being paid and so forth. One party said, well, no, an arbitrator can't decide disputes about patents because they're matters that arise under statute. Well, Hammerslag correctly, in the view of Chief Justice Bathurst, looked at what the arbitrator was deciding on. It was not deciding the validity of the patent, he was deciding simply the rights to use the patent by contract. And he said there was no problem in an arbitrator dealing with that. I'll just leave it there, we can pursue that more in discussion. So,